Hello, I'm Debojit Das and this is LiveLaw Daily. Today, August 13th, is World Organ Donation Day, and there's some encouraging news on that front, as India recorded 20,138 organ transplants in 2025. That's the highest number in a single year so far. India also continues to lead the world in living donor transplants, while ranking third globally in total organ transplants. With that, let's get into the biggest stories from India's courts and the world of law today. For our first story today, the Supreme Court is going to examine a question that sits right at the intersection of protests, privacy, and police surveillance. The question is, can facial recognition technology and other biometric tools be used to identify people at protest sites? So what has reached the Supreme Court? CPIM Rajya Sabha Member of Parliament A.A. Rahim has filed a writ petition challenging the deployment of facial recognition technology and other biometric surveillance measures by the police at protest sites. A bench of Chief Justice of India Suryakant, Justice Joy Mallya Bagchi, and Justice V. Mohana has agreed to hear the matter and tagged it with other pending petitions concerning the recent student protests organized by the Cockroach Janata Party. And what exactly is Rahim challenging? Senior advocate Dr. Menaka Guruswamy, appearing for Rahim, told the court that the petition concerns the use of digital surveillance tools by Delhi police at Jantar Mantar. She said that two private entities named Aditya Infotech Limited and Dimension NXG Private Limited were involved in the surveillance and alleged that data was being processed and stored in violation of the Digital Personal Data Protection Act of 2023. The petition also alleges that police used CCTV cameras, drones, and a mobile command and control vehicle to collect photographs and footage of protesters, journalists, and others present at the site. So is there a law specifically allowing this kind of biometric surveillance at a peaceful protest? Well, that's precisely the petitioner's argument, that there is no legal authorization for indiscriminate biometric identification of people participating in a civilian assembly. The plea also says that neither Delhi Police's standing orders governing protests nor the Criminal Procedure Identification Act of 2022 permits such surveillance. The petition relies on the Supreme Court's 2017 Puttaswamy judgment, arguing that any state action affecting privacy must satisfy legality, legitimate aim, and proportionality. The petitioner is also seeking disclosure of the technologies and databases being used, safeguards for the collected biometric data, and a mechanism for affected people to access or seek deletion of their data. And that's now the issue the Supreme Court has agreed to examine. For our second story today, the parliament has just changed the rules on who gets to tax India's mineral wealth, and the move could significantly limit the taxing powers of state governments. So what has the parliament changed? The Rajya Sabha has passed the Mines and Minerals Development and Regulation Amendment Bill of 2026 after the Lok Sabha cleared it yesterday. The key provision is a new Section 9D. It says that states cannot impose taxes, cess, or other levies on mineral rights or mineral-bearing lands based on the quantity or value of minerals, the royalty payable or otherwise, unless the levy is in accordance with conditions or restrictions prescribed by the centre. And why is this important? Because this comes after a major Supreme Court ruling in 2024. A 9-judge constitution bench held that states do have the power to tax mineral rights and that the Central MMDR Act does not take away that power from them. The court had also allowed states to recover past dues dating back to April 1st of 2005. The new amendment now seeks to change that position going forward. It also says that certain state levies imposed before this amendment but not yet recovered or deposited will be invalidated. However, amounts already recovered or deposited with the state will not have to be refunded. The centre says that the change is needed because different state taxes and levies have created uncertainty for the mining industry, with varying rates, multiple charges, and even retrospective demands. The government's stated aim is therefore to bring greater certainty and predictability to mining taxation. And the bill was introduced by Coal and Mines Minister G. Kishan Reddy and will come into force on a date to be notified by the centre. For our third story today, Rahul Gandhi has now taken the dispute over allegations of disproportionate assets to the Supreme Court. So what is this case about? Rahul Gandhi has challenged orders of the Allahabad High Court directing the CBI and Enforcement Directorate to verify allegations made by BJP worker Vignesh Shishir, who claimed that Gandhi was holding assets disproportionate to his income. The High Court had said in May that the allegations could be verified in accordance with law and that the CBI or Enforcement Directorate could take appropriate steps. It also asked the agency to report back on their progress. The matter came up again on July 20th when the High Court expressed dissatisfaction with the CBI's response while observing that the Enforcement Directorate had taken the required steps. Rahul Gandhi has now challenged these orders before the Supreme Court. He has also filed a separate petition seeking to transfer the proceedings from the Allahabad High Court to the Delhi High Court. Both petitions were filed on August 7th and will be heard on August 17th by a bench comprising Chief Justice of India Suryakant, Justice Joy Malia Bagchi, and Justice V. Mohana. For our fourth story today, the Calcutta High Court is examining allegations that police officers across West Bengal are pressuring mosques to remove loudspeakers used for azan. So what exactly is this allegation? A public interest litigation that loudspeakers have been removed from nearly 4,000 mosques, allegedly following oral directions from police officers. The petitioner says that there is no written government order or circular authorizing such action. A division bench of Acting Chief Justice Tapabrata Chakraborty and Justice Ataro Banerjee heard the plea today. Senior advocate Kalyan Bandopadhyay, appearing for the petitioner, argued that the existing rules already regulate loudspeakers through restrictions on timings and decibel levels. His argument was that if an individual mosque violates those restrictions, the police can take action against that particular violation, but there cannot be a blanket removal of loudspeakers. The state, however, questioned the basis of the allegations. The Advocate General pointed out that the petition did not identify specific police officers, mosques, or individual instances where loudspeakers were allegedly removed. And that became important for the court, as the bench said that without specific instances, even an interim order restraining the state from removing loudspeakers would be difficult to enforce. The court asked, if we pass this order, when it comes to us in contempt, how will we implement that order? The state has now been given time to obtain instructions on the allegations, and the matter will be taken up again on Tuesday. For now, the High Court has not passed any interim order. For our next story today, Arvind Kejriwal and Manish Sisodia are now challenging the CBI's attempt to revive the liquor policy corruption case against them after a trial court had discharged all 23 accused. So what is the latest update on this case? The AAP leaders have approached the Delhi High Court seeking dismissal of the CBI's criminal revision petition against their discharge. The matter is pending before a single bench of Justice Manoj Jain. Their main objection is about how the CBI filed that revision petition. The trial court discharged all 23 accused on February 27th, including Kejriwal, Sisodia, and K. Kavita. The CBI filed its revision petition on the very same day, and according to Kejriwal and Sisodia, within just 4 hours of the discharge order. They describe this as an unprecedentedly hurried and legally defective filing. And what exactly are they saying is wrong with the CBI's petition? They argue that it is an omnibus and non-specific petition, which does not explain separately how the trial court's findings concerning each accused were legally or factually wrong. They also contend that the CBI has not identified what evidence was ignored or what material made the discharge order, which ran to more than 500 pages per verse. The trial court had also strongly criticized the CBI's investigation while discharging the accused. The case had become politically significant after Kejriwal was arrested during the 2024 Lok Sabha election campaign and spent 156 days in custody. Sisodia spent 530 days in custody in the case before being granted bail. The High Court will now consider the preliminary objections raised by Kejriwal and Sisodia against the CBI's revision petition. For our sixth story today, the Supreme Court has stepped in to pause the selection of Odisha's next Director General of Police, at least until it can examine a challenge to the selection process. So what happened here? A bench led by Chief Justice of India Suryakant directed the Union Public Service Commission or UPSC not to finalize the selection of the Odisha DGP until August 18th. The UPSC was reportedly scheduled to hold its meeting today to finalize the candidate. Senior advocate P. Chidambaram mentioned the public interest litigation before the court, arguing that the selection process was not following the Supreme Court's own guidelines laid down in the Prakash Singh police reforms case. Chidambaram also alleged that an officer was promoted just yesterday, allegedly to make that officer eligible for inclusion in the panel being sent to the UPSC. The Odisha Advocate General Pitambar Acharya rejected any suggestion that the rules had been breached. He also questioned whether a public interest litigation was maintainable in what he described as essentially a service-related dispute. And the Supreme Court itself raised that concern. Chief Justice of India Suryakant pointed out that no affected officer had approached the court. The bench then sought the opinion of Senior Advocate Raju Ramchandran, who is the amicus in the Prakash Singh matter. He supported the petitioner's case and said that the selection process was being conducted contrary to the guidelines laid down in that judgment. Taking that submission into account, the court asked the UPSC to defer its meeting. The matter will now be considered on August 18th. For our seventh story today, the Supreme Court has raised serious questions about something many people turn to when they have a consumer complaint. How long does it actually take to get a decision? So what prompted the court's concern? The Supreme Court was hearing a suo motu case concerning the pay and allowances of members of consumer commissions, when Chief Justice of India Suryakant referred to a case filed in 2019 that was listed only once in 2022 and had still not received another hearing by the middle of 2026. The Chief Justice of India described the situation as very disturbing, asking what purpose these specialized consumer forums serve if cases continue to remain pending for years. A bench of Chief Justice of India Suryakant, Justice Joy Malia Bagchi, and Justice V. Mohana has now asked the President of the National Consumer Disputes Redressal Commission or NCDRC to submit a detailed report within 2 weeks. The report must include the total number of pending cases, the strength and composition of the commission, its average disposal rate, and how long it would take to clear the existing backlog. Separate data has also been sought from the state consumer commissions. And the court is not looking only at numbers. The bench also questioned whether members of consumer commissions are actually being subjected to meaningful performance evaluation, particularly when retired judges are appointed to these bodies. Chief Justice of India Suryakant questioned whether such appointments were turning consumer commissions into a rehabilitation center without corresponding accountability. At the same time, the court acknowledged that accountability cannot come without basic working conditions. The bench flagged infrastructure shortages, while the amicus Senior Advocate Gopal Shankar Narayanan pointed out that even basic facilities such as women's toilets are reportedly unavailable at some commission premises. The court has now asked for the data first before considering how the consumer redressal systems need to be strengthened. For our next story today, the Supreme Court has once again pulled up the food regulator over how packaged foods should warn consumers about high levels of sugar, salt, and fat. So what is the issue about? The Supreme Court had earlier asked the Food Safety and Standards Authority of India to work towards mandatory front of package warning labels on packaged foods. Simple warnings telling consumers when a product is high in sugar, sodium, or saturated fat. But the FSSAI came back with a different proposal. Instead of warning labels, packages would display the recommended daily limits for these ingredients. A bench of Justice J.B. Pardiwala and Justice K. Vinod Chandran was not impressed. Justice Pardiwala said that the court's earlier February order was not merely a suggestion but a direction, and questioned whether the regulator was bowing down to the manufacturing industry. The Food Safety and Standards Authority of India said that its proposal was based on the 2024 ICMR NIN dietary guidelines. For example, 25 grams of added sugar, 10 grams of saturated fat, and 5 grams of salt per day. But the petitioner's lawyer argued that this makes consumers do the calculation themselves, defeating the whole purpose of a front of package warning. The court also pushed back against the argument that international warning label standards cannot simply be applied in India because Indian dietary habits are different. Justice J.B. Pardiwala asked whether that approach meant Indians should always remain underdeveloped and and also raised concerns about children's health. The court has now given the Food Safety and Standards Authority of India 2 more weeks to reconsider its proposal. For our ninth story today, a Kerala teacher's suspension over a quiz question on V.D. Savarkar has now reached the High Court. So what happened here? Guru Prasad Rai, a teacher from Kerala, was suspended after a question in a freedom fighters quiz asked which freedom fighter received the maximum punishment from the Britishers. The answer given was V.D. Savarkar. The question was part of an inter-school competition called the Social Science Club Freedom Quiz of 2026, held in Kasaragod in August 6th. The question then became controversial, leading to an inquiry by the Deputy Director of Education. Following the inquiry and its recommendation, the teacher was suspended and disciplinary proceedings were initiated. And what is the teacher challenging? He has approached the Kerala High Court seeking to quash the suspension order, the memo of charges, and the Deputy Director's letter. Before Justice Viju Abraham, his plea argues that the action was taken on the direction of the General Education Minister and allegedly violated the rules of business of the Kerala government as well as provisions of the Kerala Education Act. The court has now sought the state's response. The government pleader has been given time until August 17th to obtain instructions and explain the reasons for the suspension. The matter will come up again on Monday. And finally, a short update to close today's LiveLaw Daily episode. Parliament has passed the Kerala Alteration of Name Bill of 2026, proposing to officially change the name of the state from Kerala to Keralam. The Rajya Sabha cleared the bill today, a day after it was passed by the Lok Sabha. So how did this come about? The Kerala Legislative Assembly had unanimously approved the proposal in July 2026 after passing a resolution in 2024 seeking the change. The proposal had also received the centre's approval in February. The President had referred the bill to the Kerala Assembly under the proviso to Article 3 of the Constitution before it was introduced in Parliament. With the Parliament now passing the bill, the proposed name change has cleared the legislative stage. And that's all for today's LiveLaw Daily. You can find the links to all the stories we covered in the description box below. I'm Debojit Das. Thanks for listening, and we'll be back again with another update tomorrow.